We also thank all the Native Nations of Southern California, whose lands we travel, live on, and work. And we'd like to also thank the Native Nations of California and attendants of tribal and state government officials who joined us for the discussion today. We are honored by your presence and look forward to hear your perspectives on the symposium. My name is Carlos Quay.
I'm Olivia.
And we, along with Shania Wade and Zachary Burns, are the student organizers for this symposium. Each year, UCI Law provides funding and resources for a student organization to host a symposium on any topic of our choice. We're gracious for UCI Law for selecting our bid that we submitted that would address focus on specific issues confronted by Indigenous communities locally, nationally, and internationally today.
And I just want to speak a little bit about the founding of our NALSA chapter at UCI Law. When I came here, I guess almost 3 years ago, I knew that I wanted to work with Native Nations and hopefully practice federal Indian law one day, but we didn't have a NALSA chapter at UCI Law, and so Professor Davis kindly set me on the path to connecting with the NALSA area reps, and then together, Carlos Coy and Rob Modelmog and I put together a constitution, and we founded NALSA at UCI Law, I guess 2.5 years ago. And then last year, Shania got us, I guess, nationally recognized within National NALSA, and so this is really our first event, and so we are very grateful to everybody for that. Even coming down to the naming of our NALSA organization, we weren't sure how we would do that. We wanted to create an organization that would provide a space for community, for Indigenous students and their allies. And then one discussion that we've kept having is how to engage in local, national, and international Indigenous people collectively while recognizing the legitimate differences and views regarding sovereignty, regarding identity, culture, and the use of legal mechanisms such as the courts of the conqueror to advance or protect our communal and individual rights.
And this is one of the reasons we actually decided to have the symposium. It was actually to address the local, national, and international perspectives on sovereignty, so we could all come together and listen to the differences, compare experiences, figure out what's the best way for us and the UCI Law community to help support and understand the evolving and scaling legal and non-legal issues around certain topics of sovereignty and identity. And the hope is that from there we can move forward to understanding how we as students, members of Indigenous communities and tribes, and allies can participate and contribute to each other's struggles or simply respect and appreciate them. This is especially important given the time we're in. I know like everyone always says that everyone likes to assume that they're living in interesting times. I think we're especially living in interesting times now where we're confronting whole struggles in new forms. So we're hoping that we can, by sharing our stories and listening to others' narratives of their historical struggles, we can come together and discuss and think about best ways to move forward, or at least appreciate our past struggles, especially in the time of Trump. And as you guys know, on Monday, the Inter-American Commission on Human Rights, the U.S. for the first time decided not to send a representative there, and that has been so important for Indigenous rights movements locally, nationally, and internationally. Before we get started, we'd like to thank all of our amazing guests and speakers that have joined us today. Please refer to your program for scheduling details. We're respectful to be transparent for the process. Speakers will be about 5 minutes, and we'll have the moderators will moderate a 2-minute discussion after questions. And we're really grateful that you guys decided to spend your Friday here with us, and we're excited for your participation in today's program. Thank you so much.
So we would like to begin today's event with our amazing keynote speaker, Gabe Delanda. And so Zachary and I will be introducing Gabe Galanda. Mr. Galanda's practice focuses on complex, multi-party litigation and crisis management, and representing tribal governments, businesses, and members when it matters the most. Gabe is skilled at defending tribes and Indian-owned enterprises against legal attack by local, state, and federal governments and private parties, advocating for tribal members in disenrollment or civil rights defense, and representing tribal plaintiffs and defendants in catastrophic personal injury lawsuits. Gabe also assists tribes with economic development strategies and transactions. He is trained by the American Arbitration Association. He also arbitrates disputes between tribal and non-tribal governments and other parties, as well as mediates such disputes. I had the pleasure of meeting Mr. Galanda last year at the Federal Indian Bar Conference and the National NALSA Conference, and he was an amazing speaker and a great person to connect with and to talk about the issue of disenrollment with. And so I am very honored today to have him here at UCI and to have him speak for our inaugural event. So with no further ado, I would like to introduce Mr. Gabe Galanda.
Good morning, everybody.
Good morning.
I'm honored to be here. My name is Gabriel Galanda. I'm an enrolled citizen or member of the Round Valley Indian Tribes from Northern California. Our ancestral homelands far and wide throughout Northern California, but by way of a lot of the missionization and other colonialization of Indians in Northern California, and by way of even a trail of tears into our current homelands, Round Valley. Round Valley is not our ancestral homelands. At least it's not the homelands of the tribes I descend from, the Nomlaki and Concow tribes or bands. We exist in what is Yuki territory, and we coexist as a confederation of tribes thanks to all of those forces. But I'm very proud to belong to Round Valley. I'm very proud that my great-grandma was an original Alati of Round Valley, and I'm very grateful to be here today with you all. I want to extend a special thanks to the Luiseño and Juaneño people for allowing us all to be here on their homelands. I want to extend special thanks to the law students who could not have picked a more brave or bold or powerful topic. Tribal identity is the single most important issue of our time, without question. It's not necessarily land or treaty or certainly gaming. It is identity. And all of those other things do inform our individual and collective identity. But I just want to thank Shenya, Carlos, Olivia, Zachary, Professor Davis, and everybody for making their first event perhaps the most powerful topic of an event that you could possibly have been put together. It was brave and bold, and for that I applaud you all. It makes me even more honored to be here today. The tribal president alluded to it, but we're in a time where tribes are fighting as much, if not more, with each other and their own people than they are with outside forces. And I'd be remiss in not at least acknowledging that Southern California has become a bastion of tribal capitalism and consumerism, perhaps more so than tribal cultural protection. You have tribes fighting the recognition of other tribes. You have tribes jettisoning their own relatives. You have tribes fighting over gaming monies that come in per capita distributions to their members from tribal casinos. Historically, those are not our ways. You coexisted by and large peacefully with one another. That's not to say there weren't wars amongst and between tribal nations or tribal peoples. But for the most part, money was not something that divided us and conquered us, both tribe to tribe and tribe to member, as we are now witnessing in this day and age. Again, making this topic so very important and so powerful. What I want to talk about today is the evolution of the last 200 years of federal Indian law and policy that informs or confuses who we are as Indian people today. Those laws, those policies are genocidal, they're colonial, they're federal, they're terminationist, in many, if not most respects, they're non-indigenous. And that leads us to today's, what I believe is an identity crisis. A crisis of identity amongst and between tribal governments, communities, and nations, and amongst and between a tribal community and nation and its own people. And that's why these conversations have to happen. They have to happen in places like this. I don't want to cast stones, but I have to acknowledge that the UC system and the UC legal system has not been particularly great about confronting these issues for the last 2 decades, when they've become so acute in Indian country. Some of the brightest legal minds ever, or certainly of our time, have come from that very system. But there has been a dearth of discussion, a dearth of study, a dearth of advocacy coming from the academic system, and I'm not just trying to blame the UC system, but the academic system at large, the legal system at large, the legal academic system at large. As a result of the failure to have these conversations, these genocidal and colonial forces become more and more empowered. So critically, one of the most powerful things we can do is to be here today together, to have conversations and perhaps debate these things, because that's the only way we will beat back the forces that are overcoming us. I also want to recognize my friend Dr. Joe Graham, who I knew 20 years ago when I was a baby law student, and I want to congratulate him on completing his PhD. And I was
Did you say
delighted
baby
to
law
be here with you all. That gives me hope.
That means you're an infant.
My topic is who belongs,
I'm so.
bullet quantum, identity, and sovereignty. And I want to start with the words of Chief Mankiller, which says it like it is, very simply, very beautifully. An Indian is an Indian. And just pause right there. It's really that simple. An Indian knows who an Indian is. They also know who a wannabe Indian is. But what you certainly don't need is a certificate of Indian blood or some notion of blood quantum that is biologically impossible. You don't have 50% of a certain type of Indian blood. You either have type O blood or some other kind of blood, but this 50% of me is not some component of Indian blood. These are racialized notions of what it means to be an Indian that are not our notions of what it means to be an Indian. And more simply, what it means to be an Indian is kinship. Before we were nations, before we were governments, before we were citizens, before we were members, before we enjoyed per capita, we were kin. We were relatives. We were clan. We were moiety. We were society. There were certainly some notions of government, but very simply, we were related. Say what you will about the Dances with Wolves narrative, but I like the idea that in the interest of humanity, the non-native officer and his non-native wife were brought into the tribe as a matter of relationship, as a matter of kinship, irrespective of race. Because the humanity was we were not going to leave people for dead. That included our own, that included other Indians, that included Africans, that included slaves, that included Europeans. Because we were related, and we had an interpersonal connection with one another. The best story about kinship that I'd like to share with you is one in the disenrollment context. We've had the good fortune in my firm of representing 86 direct descendants, enrolled members of the Grand Ronde Confederation of Indians in Oregon. They descend directly from Chief Tumult, who signed the Treaty of the Calapooya Indians in the 1850s. that treaty ultimately established the Grand Ronde Reservation. Before he and his people could get to the Grand Ronde Reservation as we currently know it, he was hung by Officer Phil Sheridan, renowned Indian fighter. But several generations later, or over a century later, his direct descendants belonged to Grand Ronde. A few years ago, there was a challenge to their ancestry, the suggestion being that even though the requirement under an IRA constitution that they hail from someone who was on a roll or record prepared by the Department of Interior, somehow they did not fit that criteria. Well, the seminal record of the Grand Ronde Indians is the Treaty of Calapooya, which bears at least an X of their ancestor, who again was hung in part as a result of signing that treaty. There could not be a more seminal roll or record of the Department of Interior establishing belonging in Grand Ronde. But if that weren't enough, there was a woman named Susan. In the 1850s, chiefs like Tumbolth had multiple wives, and one of his wives was named Susan. Well, Susan Tomolka or Tomolcha, depending on the spelling by a non-Indian person in the 1800s, appeared on a federal census. And we looked at all the variations of the word Tumbolth, and you would see about 15 different variations or misspellings by non-Indians of Tumbolth, suggesting that that was exactly the Susan that other evidence suggested was one of his wives. Another roll or record of the United States establishing belonging at Grand Ronde. I think for a minute we're using colonial records to establish how we belong, which is a problem in and of itself. So then the question, well, how do you establish that Tumbolth was married to that Susan? And then how do you establish that Susan gave birth to a famous Indian in the Northwest named Indian Mary? And how do you then establish that Indian Mary gave birth to her children? And it's very difficult to go back in time when forced to ask and answer the question of whether you belong to find records, especially tying an Indian mom like Susan to her daughter Indian Mary in the late 1800s. Well, we weren't even citizens until 1924. And Indian women in particular weren't held in the highest regard by non-Indian government. So were they issued birth certificates? Probably not. Were they issued death certificates? Probably not. Is there some other record establishing ancestry between Susan and Mary, my folks were asked to furnish with a proverbial gun to their head, suggesting they don't belong, and on some certain date they must come up with a record suggesting that they do? No, there's no roll or record beyond what we've already produced. But what there is a cemetery, albeit a non-Indian cemetery in Skamania County in south central Washington. And there you have headstone next to headstone next to headstone. And Susan's headstone, announced as wife of the chief, sits next to Mary's headstone. And their other relatives' headstone sits next to those headstones, and so on and so forth. That wasn't good enough to suggest that Susan and Mary were mother and daughter. Most profound were Skamania County Cemetery records that suggest that Indian Mary's two young children predeceased her. For what force, I don't know. Could have been smallpox, disease, famine. Her two young children were buried not next to mom or grandma, but with Susan. They opened up Susan's grave at that time to place these two young bodies with grandma. That's kinship. Granted, that's in a non-Indian cemetery with non-Indian cemetery records. But fundamentally, you bury your deceased as kin, just as they live together as kin. But in 2016, that type of proof or evidence isn't enough in the minds of some to prove who belongs. That these children were held so sacred to their mom that they were entrusted in their death to the care and custody of their grandma, who had also passed. That's what it means to belong. That's what it means to be kin. That's what it means when Chief Mankiller says an Indian is an Indian, irrespective of a certificate of Indian blood or certainly blood quantum. Belonging. A close relative in my mind to what it means to be kin. And of course, as referenced in the United Nations Declaration on the Rights of Indigenous Peoples, which in 2010 President Obama endorsed on behalf of the United States, says, indigenous peoples and individuals have the right to belong to an indigenous community or nation in accordance with the traditions and customs of the community or nation concerned. The story of Chief Tumulth and one of his wives and their daughter and their children or grandchildren. That's what it means to belong in the custom and tradition of the now Grand Ronde people. Not necessarily that the treaty chief put his X on that treaty or his wife was incorrectly placed on a roll or census in the late 1800s. What it means to belong is, again, something more human than that. But it's important to recognize under international law, it's not a right of membership, it's not a right of citizenship, it's a right of belonging. And this pan-indigenous human right, I believe, is very profound. But then came Chief Justice John Marshall in the 1800s. And he declared in Cherokee v. Georgia that we were nations. Domestic dependent nations, mind you, but nonetheless, we were nations. And with the notion of nations comes the notion of citizenship. Again, the United Nations doesn't talk about citizenship, it talks about belonging. Professor Rob Williams, who some of us in this room know and love, delivered a speech in Tucson a few weeks ago that I was very fortunate to attend. And he is the Indian legal historian of our time. He has deconstructed the word citizenship, not just as it relates to Indians, but as it relates to any society. And he deems citizenship a racial formation. And he defines this by way of other scholars to refer to the process by which social, economic, and political forces determine the content and importance of racial categories, and which they are in turn shaped by racial meanings. He points out that citizen is a word derived in the early 14th century that means the inhabitant of a city, as opposed to those who do not inhabit the city. He then goes on to describe the evolution of this term or this idea to discuss the word denizen, which was a word derived in the early 15th century, which means to live within or inside. And again, by way of citizenship or inhabitants of the city. His point is the notion of citizenship has always been one of exclusion. You are a citizen of, you are a denizen of, meaning there are those who are not a citizen of. They are not a denizen of. They do not inhabit the city. His point is citizenship is inherently and has always been exclusive, not inclusive. Kinship, on the other hand, belonging, are inclusive. So his point is, this is great that we exist today as nations. And we certainly are surviving today as nations now, some 200 years after John Marshall declared as such. But be careful in this nationhood model of adopting notions like citizenship that are inherently exclusive rather than inclusive. I personally prefer citizenship to membership only because I don't have an alternative yet that fully embraces kinship or belonging within the modern nationhood model that is under siege by a number of forces. But the reason I especially like citizenship is, to me, it's a matter of birthright. Again, think of the chief and his wife, and Indian Mary, and her children, as a matter of both birth and death. That is belonging and kinship as a matter of birth and birthright. And I liked how Carlos talked about the uncertain times we're in, especially in Washington, D.C., especially on the issue of citizenship. But the United States Constitution declares, in the 14th Amendment, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States in the state wherein they reside. If you are born here, you belong here. And it's very simple. There are 3.3, as I have read, million so-called children of immigrants that are under siege right now by this administration. They were born here to undocumented members of our society, but But under the 14th Amendment, they belong here. Yet they're under siege. And they might not be subject to deportation, but their parents are being subject to deportation and dislocation. So I appreciate the analog of the 14th Amendment. If you are born unto your parents as tribal citizens or members or those who belong, you belong. If you are born unto the land where they belong, because there's a geographic reference here, you belong. Similarly, 8 U.S.C. 1401, subsection B. The following shall be citizens of the United States at birth. A person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe. If you are born unto the land, if you are born unto the people of the land, if you are born unto your parents, you belong. So to me, citizenship has a very schizophrenic meaning today. It comes from a place of exclusion, but at least in modern times, in the colonial construct that we all live in, federal construct we all live in, there's protection to be had for those who are born unto the people or the land. And for that reason, I embrace citizenship. But looking back in history, I already referenced the Marshall Trilogy of the 1800s. Of course, at that time, the idea and the mantra was manifest destiny. And it was at that time when this racialized formation of Indian blood began to take hold by way of colonizers, settlers, and ultimately federal officials. And of course, the whole notion of blood comes from Europe. Think about the term blue blood. You were born into nobility. Think about the idea of the one drop rule. If you had one drop of African or Negro blood, you were deemed African or ultimately black or subjugated to something that was lesser than. For Indians, here's a state statute. In Ohio, in 1856, the statute was adjudicated, where an Indian was determined, oddly by state law, by preponderance of blood. Quote, persons of Indian extraction who have a preponderance of white blood are declared to be, quote, free white citizens, quote, within the meaning of the Constitution and laws of Ohio. Those quotes and subquotes are from a case decided in 1856. For purposes of manifest destiny or removal, these notions ended up in treaties at a time where the United States was identifying chiefs for purposes of dispossessing Indian communities of their land. And in those treaties, which forced the removal of Indian people away from their homelands and into other lands, or relegated them to some small fraction of their ancestral homelands, blood quantum started to be sewn into the fabric of those treaties and into this nation-to-nation relationship that was invented by John Marshall. My point is, treaties and blood and this identification of Indians as mixed blood or by preponderance of blood was all for sake of dispossessing us of our homelands. And those forces are alive and well today. By the late 1800s, you have the Dawes Rolls. And I've already alluded to them. That's basically how Grandma or wife Susan appeared on these censuses in the late 1800s. What the United States did on rather short time was prepared lists of Indians, rolls or records of Indians for purposes of pulverizing the communal land base that had just been reserved by the treaties in the early 1800s, pulverizing them into fractionated ownership so that they would ultimately pass from communal ownership, where there's strength and power and numbers, to individual ownership, where that strength is weakened, and ultimately from Indian to non-Indian ownership, allowing the Indian land base to be pulverized or decimated. So that roll or record bearing Susan's name was one such of those rolls or records. That's consistent with the deprivation of tens of millions of acres of Indian land through allotment, the great pulverizing force according to the president at the time. And again, Indian blood sowed its way through that entire effort. Because by 1906, when the Burke Act was passed, now if you were a mixed blood Indian, you were deemed competent. Meaning some component of your blood was European rather than Indian. And rather than being necessarily inferior or ignorant, you were deemed competent for purposes of having the land that had been allotted to your family under the Dawes Act now passed into fee title ownership, and ultimately out of Indian ownership altogether. The law that doesn't get talked about in the 1900s is the Lacey Act, the counterpart to the Dawes and Burke Act, where tribal communal monies, not lands, were prorated to Indians. Again, Indians of mixed blood being quote-unquote competent, for sake of pulverizing the communal wealth of the community and in turn the tribe itself. What's important about the Lacey Act is the pro rata distribution of tribal communal monies to members for sake of assimilation. And I'll talk in a minute about the Indian Gaming Regulatory Act of 1988, as a law that has done just that. And everyone talks about IGRA and per capita and what's done to us as Indian peoples, or maybe they don't talk about it enough. But it's important to recognize this idea of a per cap has been around about 110 years. And this idea of a per cap, or pro rata distribution of tribal communal wealth, came at a time when the United States was trying to pulverize us out of existence. So the next time you see the word per cap or hear about a per cap, a Salazar per cap, a Rama per cap, a gaming per cap, a general council meeting per cap, pause to realize that that's 110 years of colonial turned federal influence. And that per capita has been federally designed to do what it's doing to us today. Exterminate us from within. By 1934, the United States introduced membership to us, as I alluded, under the Indian Reorganization Act. Again, historically, we were family. We were relatives. We were kin. We belonged. By the early 1800s, we became nations, and as nations, citizens, perhaps. But by the 1930s, after this failed experiment of allotment and assimilation, the United States decided to make us into basically clubs. You are a member of a club, as Joe Calt and Steve Cornell famously say. You are a citizen of a nation. We have become members of a club, thanks to the United States government in 1934. And with membership came a couple things. Quarter Indian blood to be a member, and residence on the then existing reservation. I'm not so offended by residence, albeit paternalistic, but again, blood quantum, now defined as a quarter Indian, or it was mixed blood, preponderance of blood, 1 drop of blood. The United States, as of 1934, quantified for us what it means to belong as a result of this artifice or this fiction that is the blood running through your veins. And the very sad reality is for the last 80 years, we have adopted blood almost wholesale as what it means to belong. It too is a racialized formation, perhaps the most predominant racialized formation in Indian country. We look at each other as Indians and we see a light-complected Indian and cast doubt on their authenticity. We see a dark Indian and perhaps presume they're a full-blood when perhaps they're not. Perhaps they're not even predominantly of Indian blood, perhaps of mixed race. A racialized formation that has affected us in countless ways. We've been brainwashed, perhaps even assimilated into believing that blood, or quantum of blood, drop of blood, preponderance of blood, is somehow what makes us Indian. And it's not. Call what Chief Mankiller said. It's not the blood that says that an Indian is an Indian. And by 1988, or some period of the late 70s or early 80s, but certainly since 1988 when the Indian Gaming Regulatory Act was passed, $30 billion annually has been infused into Indian country. What Professor Wilkinson, Charles Wilkinson, calls a forced cash economy has been foisted upon Indian country. New money to Indian country, new wealth to Indian country, which does not suggest we were poor in 1492 or before the Constitution or before treaties. But this is new wealth in ways that has been introduced to us that are foreign. This is consumerism, capitalism, and consumerism by way of this act, and in particular, by way of the per capita provision of the Federal Indian Gaming Regulatory Act that has consumed us as Indian people. The most powerful force in Indian country today, as a matter of governance and identity, is per capita. It is ripping us apart as Indian people at the seams. When you have communities that cannot gather a quorum of their membership on a Saturday to have a general council meeting unless they provide it per capita, you have a problem. When you have 80 tribes in the country, half of which are in California, disenrolling their members in order to proportionally increase the per capita dollars paid to those who remain on a monthly or annual basis, you have a problem.
Yeah.
When you have politicians of tribes worried about sustaining per capita payments to their membership so that they fight the existence of another tribe or the establishment of a reservation of another tribe so that they have homelands too because it will cut into their gaming market share, we have a problem. And that is the day and age in which we live in. Per capita born unto us in 1906, not 1988. And per capita which is overcoming us in 2017. To the point where tribes are imposing moratoriums or moratoria on enrollment. They are refusing to enroll their own children. I'll talk in a minute about disenrolling their current relatives who have been enrolled. But think about that for a notion. Just look at the idea of 7 generations. You are refusing to enroll the next generation, which of course will impact the generation that follows, and the generation that follows, and so on and so forth. We cannot sit here and profess the 7 generations notion if we're not including our children. And we sure as hell will not be here in 7 generations if we do not include our children. But per capita has become so predominant that we are doing the unthinkable. We are not including our children, which creates geographic difference between families, racial difference between families, class difference between families, and ultimately acts as an exclusionary device to the detriment of the entire community and its well-being. And that brings me to disenrollment. And I'm going to spend the balance of my remarks talking about the epidemic that is disenrollment. As I said earlier, according to Professor Wilkins, 80 of the 567 federally recognized tribes in our country have in some way, shape, or form participated in this act of disenrollment. Disenrollment was also born in 1934 by the Indian Reauthorization Act. Meaning they declared us members with quantum and residential requirement, and then they declared a way by which you could get rid of your members. When I go into communities that are suffering from disenrollment, I will ask the families that I'm representing a couple questions. One, where are the cultural pillars of your community? Who in times of crisis and strife and fighting or infighting can resolve things peacefully, traditionally, culturally? The sad answer to that question is there's usually no one to point to, because that community has been decimated by all the forces I've just talked about for the last 200 years. The indigenous capacity as a matter of tradition or custom to self-resolve has been destroyed, be it through traditional or non-traditional means. The second question I ask, which is more profound, if you still know your language, is there a word that means, connotes, or comes close to disenrollment? No. And if anyone in the room knows their language and knows a word, I'd be interested in knowing it. In every community I visited where they're suffering from disenrollment, they say no. There's a traditional word for what it means to belong, or to be of the people, or to be of the land, or to be kin. But there's no word of what it means to not belong by way of disenrollment. There's banishment reserved for the most extreme circumstances in which a person would do something horrible to one's relative or the people. And traditionally that was meted out as punishment in the most extreme circumstances, and there's words for that, but there's no word for disenrollment. And banishment and disenrollment are two distinctly different things, at least traditionally speaking. When 15% of tribes in the country have participated in this act that is non-indigenous to get rid of their own relatives, and we're talking about 10,000 individual Indians, depending on the estimates, we're in an epidemic. And the reason this conversation is so important is I believe these conversations hold the cure to the epidemic that is disenrollment. And so now, hearkening on the legal battles part of the program, I want to just impart to you all, the next generation of Indian lawyers, some strategies for defending the next disenrollment, because there will be one. And we're in the epicenter of disenrollment. Half of those 80 tribes are from California. I believe the vast majority of them are from Southern California. And it results from colonization, missionization, capitalism, most notably gaming. We are doing unto ourselves what the oppressor in a place like Southern California has done to Indian people here for the last several centuries. But it can be combated. Most importantly, it's a race against time. The disenrolling politicians I have seen disenroll families spontaneously on a Saturday afternoon general council meeting. In California, thanks to Public Law 280, there are not many tribal courts, because in the 1950s, Congress told California that they could unilaterally usurp tribal civil adjudicatory jurisdiction over Indian country. State courts have authority, thanks to Public Law 280, to adjudicate a disenrollment, but they won't, because it's an internal matter. Thanks to Santa Clara Martinez, which we'll talk about in a few minutes. So thanks to Public Law 280, you probably don't have a tribal court. If you do, sad reality is the tribal court may be established by the people who are disenrolling you. The judge may be appointed by the people who are disenrolling you. The judge may be paid by the people who are disenrolling you. And in fairness, the judge's livelihood, his or her ability to put food on the table for his or her family, is dependent on the people disenrolling you. So it's a very tough position for that person to be in. But you may not have redress tribally. For reasons I just said, the state courts typically don't get involved, even though they could and should. For reasons I'll discuss in a few minutes, the federal courts typically don't get involved because of the Santa Clara Martinez case. And then typically, tribal politicians shut down the political forum for discourse in a tribe, or the traditional forum for discourse and resolution of the tribe. No community meetings, no general council meetings, no newsletter communications, no Facebook posts. They shut down communication. So you ultimately find yourself in a race against time and against all odds. It might not be a disenrollment on a Saturday afternoon in front of a general council with no ability to do anything about it for the reasons I mentioned. It could be 28 days notice. But good luck on 28 days notice proving by whatever standard of evidence has been foisted upon you that you belong. I know I belong because my grandma and great-grandma told me. I know my tribe, grandma and great-grandma have told me my great-grandma was an original Lati of the Round Valley Indian Reservation. But all I have is a family tree and what I've been told. And I have a certificate from my tribe when I was young that references my grandma as an original Lati. Again, allotment being one of the colonial forces of assimilation. So I have these two pieces of paper. And then what I otherwise have is what's in my mind and my heart. Whether on 24 hours or 28 days notice, I could not prove to you by some high standard of evidence or best evidence that I belong beyond those two pieces of paper. And I would doubt if anyone in this room could. But that's what disenrollees are asked to do. On very short in time, prove by some colonial measure that you belong. Go to the DC archives. Go to the archives in San Bruno. Go to the archives in Sandpoint, Washington. Go to Provo, where the Mormons have gathered everyone's genealogical records. Get on Ancestry. It's never enough, and there's never enough time to prove it. The Tummel folks joked, we're looking for the magic unicorn. This story of the cemetery and belonging, which is so obviously true, doesn't add up because they could not find the birth or death certificate of Susan, an Indian married 1900, because they didn't exist. And they were literally going in tombs in a place like Skamania County balls to find records that simply didn't exist. More or less to prove that they could not be found, and it was never enough. The challenge is that disenrollees are in a race against time. Oops, how do I go backwards? If there's jurisdiction, you have to find it, or you have to find some waivers of sovereign immunity. Santa Clara Martinez case in 1978, it's a beautiful decision in some respects. It's the worst Indian Civil Rights Act case ever decided in other respects. It's beautiful in that it helped establish judge-made law that affirms the immunity of tribes. The immunity of tribes from attack by states and attacks by private citizens. And without that case, we wouldn't have cases in the 80s, 90s, and more recently from the Supreme Court affirming that tribes cannot be sued, especially by state government. States being our deadliest enemy to this day. Without that case, there wouldn't be the Kiowa case of the 90s or the Bill McVeigh Mills case of very recently. Again, putting up a threshold defense to state incursion in Indian country. But that case said that Ms. Martinez did not have a federal right of action under the Indian Civil Rights Act or habeas corpus in a federal court to compel her membership in the Pueblo. That's all it said. No private right of action under the Indian Civil Rights Act to state a claim against tribal officials or Pueblo to compel membership. And further,